The Honorable, the Judges of the United States Court of Appeals of the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this Honorable Court.
Please be seated. Good morning. Unfortunately, at the court, we've identified some positive COVID cases here. So we're going to be extra careful this morning. Normally, I would allow counsel to take off your mask, but let's keep them on. Try to speak as clear as you can. The other piece of advice as to all of the counsel coming, we seriously considered whether we would decide these matters on the briefs in light of the COVID cases, but we're going to forge forward. But that means we're going to do so expeditiously. So if you will go directly to the issues and address the matters, you don't have to take up all of your time because we do have your briefs. If you wrote them as well as you are lawyers out there, we're confident we'll have that. There may be a few fine points we want to question you on. So with that, we are ready to proceed. And the first case for argument is United States versus Goodwin, and we'll hear from the appellate's counsel first.
Good morning, Your Honors, and may it please the court. My name is Maya Eckstein with Hunton Andrews Kurth, and I represent Mr. Leroy Goodwin on appointment from this court in pro bono. Your Honors, the court appointed me to address a very specific issue, whether under the First Step Act, a district court may consider Section 401's non-retroactive amendments when imposing a new sentence under Section 404. I'm prepared to jump straight into that issue.
Can I ask you before that, don't we have to answer the question whether he was already sentenced under the Fair Sentencing Act? Are you aware of our decision last year in U.S. versus Garcia?
Yes, Your Honor. With respect to the eligibility issue, which I'm prepared to address as well, the government has raised a question as to whether he is eligible on that basis. What Section 404 states is that a defendant is not entitled to a resentencing if he was previously sentenced in accordance with the amendments made by Sections 2 and 3 of the Fair Sentencing Act. Mr. Goodwin was sentenced in September of 2012, so certainly after enactment of the Fair Sentencing Act. But the First Step Act does not look merely at the date of resentencing, at the date of sentencing.
That's why I asked about Garcia. In Garcia, we said if you're sentenced after the date of the Fair Sentencing Act, after Dorsey, and there's nothing in the record that indicates you were not sentenced in accordance with the Fair Sentencing Act, then we're going to say you were.
Correct. I understand. Okay. And in this case, nothing in the record indicates that, other than the date of sentencing, that Mr. Goodwin was sentenced in accordance with the Fair Sentencing Act.
Sure it does. His sentence complies with it, doesn't it? Because of the conspiracies, two objects, just like in Garcia.
That's correct. With respect to the 50 grams of crack cocaine, that 50 grams, though, has no meaning under the Fair Sentencing Act amendments to Sections 2 and 3. That was never changed. It was never modified in any way in his indictment and his plea during the sentencing. Everything involved in his sentencing suggested that he was still being sentenced under the older rules.
No, it's because it's a dual object conspiracy. He was sentenced for the cocaine, right? Not for the crack.
Our position is that he was sentenced for both the crack.
Okay, but you know that was the same factual predicate as Garcia, and we held to the contrary in that case.
I believe in Garcia there were different facts as well that suggested that he was sentenced in accordance with the Fair Sentencing Act. Here, our position is that he was not, because that 50 grams simply has no meaning under the Fair Sentencing Act.
I want to ask you a question about the government's other eligibility argument that he didn't plead guilty to a covered offense.
Yes.
It seems like the parties are disputing what offense the defendant pled guilty to. And so I wanted to ask you if we assume just hypothetically that I thought the plea agreement was ambiguous, that there were some inconsistencies on this, and that the colloquy also had some inconsistencies, what would follow from that?
Well, the court has held that the government must be held to a greater degree of responsibility than the defendant for any imprecision in a plea agreement, so that ambiguities are construed against the government. And while there is some imprecision here and ambiguity here, there's no question that the superseding indictment did indict him for charge a multi-object conspiracy involving both crack and powder cocaine. At the sentencing hearing, the district court read count 1 as it was written in the superseding indictment, charging a conspiracy involving both. The district court even asked Mr. Goodwin, quote, if he admitted or denied that he was involved in a cocaine and crack cocaine conspiracy, end quote, which he responded that he did. That was at page 234 of the joint appendix. And the government agent who testified repeatedly, to Mr. Goodwin's conduct as it related to crack cocaine. The plea slip also referenced count 1 as it was count 1 in the superseding indictment without any reference to deletion.
So your position is it's not ambiguous. It's clear that he pled guilty to the both objects of the dual object conspiracy. Because we also have cases suggesting that if there is actually no meeting of the minds as to what offense the defendant pled guilty to, then there's no plea agreement and we have to vacate the conviction and start again.
I do think that the preponderance of the evidence certainly points to an agreement here that he was pleading guilty to a multi-object conspiracy. I agree, I concede that the plea agreement itself, while referring to count 1 of the superseding indictment, which again referred to both crack and powder cocaine, it then recited the elements by referring only to powder cocaine. I think that's where the ambiguity could arise to the extent that there is one. But again, the court has held that ambiguities such as that should be construed against the government. Now, with respect to the question for which I was appointed, a ruling that Section 401's non-retroactive amendments may be considered when imposing a new sentence under Section 404 would be consistent with the court's precedent, with the language of the First Step Act, and with its remedial purpose. Through the court's line of precedent in Worthing, Chamber, Collingtons, and Lancaster, the court has held that district courts must make holistic resentencing determinations under the First Step Act. That means that district courts must accurately calculate the guideline sentencing range, correct original guidelines errors, and apply intervening case law, whether retroactive or not. We know that from Collington and Lancaster, and consider the Section 3553A factors to determine the appropriate sentence within the guidelines range. Having ruled that non-retroactive changes in case law must be considered, there isn't a principled reason not to also consider non-retroactive changes in the statutes. As the court has held, Section 404 does not impose limitations on what may be considered in connection with a 404 resentencing. The court has held the same with respect to 3582C1B, under which 404 resentencings occur. Just as there is under Section 404, as the court said in Chambers, no limiting language to preclude the court from applying intervening case law, there is no limiting language to preclude the application of intervening legislative changes. This is also consistent with Section 404's directive to impose a reduced sentence and the court's interpretation of that phrase. As the court has held, impose, that term impose signifies that the court should not merely adjust the statutory minimum, but conduct a holistic resentencing. A reduced sentence under Section 404 is not a continuation of the defendant's original sentence, but the imposition of a new sentence based on the penalties that apply at the time of sentencing. It would be inconsistent with Section 404 not to so hold here. 404 is not predicated on a pre-existing sentence that is merely modified. The word impose contemplates a robust resentencing process, not plenary, but robust. The language in Section 401 also supports this conclusion. Section 401 states that it shall apply to any offense that was committed before the date of the enactment of the Act, December of 2018, if a sentence for the offense has not been imposed as of such date of enactment. Notably, both Section 404 and 401 use that term imposed. Section 401 does not say that it shall not apply if the defendant was previously sentenced. It says if the sentence has not been imposed.
Hasn't the sentence been imposed? I don't understand how that language helps you.
I understand. The distinction here is that that same language is used in Section 404. 401 itself is not self-executing. A defendant cannot come to the court and say, I deserve a resentencing under Section 401. 401 can apply only when a sentence is imposed, and Section 404 provides that vehicle, having used the same language. And as the court has held, the First Step Act contemplates a robust resentencing analysis. The First Step Act, along with the Fair Sentencing Act, together they've been described as strong remedial statutes meant to rectify disproportionate, racially disparate sentencing penalties. And Congress chose to correct those disparities by broadly empowering district courts to resentence defendants. A ruling here that Section 401 can apply in a 404 resentencing furthers that remedial purposes. Several district courts within the circuit have so held. There are courts in the District of Maryland, the Eastern District of Virginia, District of South Carolina, I believe also District of West Virginia. I particularly find Judge Trenga's reasoning in the United States versus Day case to be well thought out. I think it's a good example of the analysis. The defendant there was convicted of a multi-object conspiracy involving both crack and powder, like here. He received a enhancement under Section 851 for a mandatory life sentence. Nobody disputed that with Section 401, he would no longer be eligible for the enhancements. And I believe there's no dispute here that Mr. Goodwin would be no longer eligible for the enhancements that he received either. After finding the defendant eligible for a Section 404 resentencing, Judge Trenga ruled that the intervening legislative changes in Section 401 should be treated the same as the judicially corrected guideline errors in Chambers. He explained that neither 404 nor 3582C1B limit what can be considered, and also explained that Section 401 supported that conclusion for the reasons that we've discussed. Your Honors, I would turn to the words of Judge Trenga in his decision in Day, in which he explained that the imposition of a new sentence under Section 404 without the benefit of the intervening change in Section 401 would reduce 404 to the absurdity of authorizing a reduction in a sentence that is irreducible. And that cannot be what Congress intended. And as a result, we urge the court to vacate the lower court's ruling and remand so that it may resentence Mr. Goodwin under Section 404 with the application of Section 401. If there are no further questions.
Judges, further questions? Thank you very much. We will hear from the governor.
May it please the court, Fanula Tessier on behalf of the United States. Mr. Goodwin pleaded guilty and was sentenced after the Supreme Court's decision in Dorsey, finding that the Fair Sentencing Act applied to defendants who are just like Mr. Goodwin, whose conduct predated the statute and whose sentences postdated it. He was also sentenced after this court's decision in Jones, which had already reversed sentences that violated the ruling in Dorsey. As a result, the plea agreement, although Mr. Goodwin was charged with conspiring to distribute both 5 kilograms of cocaine powder and 50 grams of crack cocaine, the plea agreement set forth the elements for only the cocaine powder object of the conspiracy, the penalties for which were unchanged by the Fair Sentencing Act. At his plea colloquy, the district court instructed Mr. Goodwin that the only quantity of drugs that he had to allocute to was the 5 kilograms of cocaine powder that was set forth in the plea agreement. He was sentenced to the minimum sentence that was available under the Fair Sentencing Act for an offense involving 5 kilograms of cocaine powder. As a result, he is ineligible for a reduced sentence for 3 different but related reasons. First, under Section 404C, it provides that no court shall entertain a motion made under this section if the sentence was previously imposed in accordance with the amendments made by Sections 2 and 3 of the Fair Sentencing Act. There's no dispute that Mr. Goodwin's sentence did in fact comport with the Fair Sentencing Act, and he is therefore ineligible for further relief. Second, he is ineligible because under Section 404, because he was not sentenced for a covered offense. At most, the plea colloquy supports a finding that he agreed that he participated in a conspiracy involving some amount of crack cocaine. At the time of his First Step Act motion, this court's precedent stated that an offense involving any amount of crack cocaine was a covered offense. The Supreme Court has...
So can I just ask you about this? Because he says he pled guilty to count one, and count one charged him with a specific amount of crack cocaine. And it does seem like we have this weird case where the parties actually, that your argument on this has surfaced what appears to be a genuine dispute about the most fundamental element of a plea agreement, which is what did the defendant plead guilty to. The record appears to be ambiguous on that. There's an inconsistency in the agreement, which I gather the government drafted. And I mean, you've referred to it as a Scrivener's error. And so now I don't know what this guy pled guilty to. And we do have case law saying that if we can't tell what crime a defendant pled guilty to, then there's not a valid plea agreement. It's a contract, and there's been no meeting of the minds, and we have to vacate the conviction and start again. Why does that not apply here?
Your Honor, I think that case law applies where there is no agreement at all as to whether or not what the defendant pleaded guilty to.
Well, you all
There
don't
is-
agree.
Well, there is some agreement as to what the defendant pleaded guilty to. There is agreement that Mr. Goodwin pleaded guilty to a conspiracy to distribute 5 kilograms or more of cocaine powder. And that is sufficient for the plea agreement and his conviction to be considered valid, because there is clearly a valid object of the conspiracy. The question is whether he pleaded guilty to both a conspiracy to distribute 5 kilograms of cocaine powder and a conspiracy to distribute 50 grams or more of crack cocaine. That's the only place where there is disagreement. And so because there is, I think Your Honor would be correct if there was no agreement that there was a valid conviction here. But because there is agreement as to one valid object, then I don't think that there's any need to question the validity of the conviction. I would note, I do think the easiest way for the court to resolve this case is under 404C by finding that the defendant was already sentenced in accordance with the amendments made by sections 2 and 3 of the Fair Sentencing Act. I think it's important that Congress here drafted 2 separate eligibility provisions. First, the covered offense, and second, recognizing that there were defendants whose conduct predated the Fair Sentencing Act, but who were in fact sentenced in accordance with that act, specifically included this 404C, precluding relief for defendants who have been sentenced in accordance with the amendments made by the act, as Mr. Goodwin was here. Even, however, if he were eligible for a reduced sentence, the district court correctly determined that it did not have discretion to sentence him below the 20-year mandatory minimum sentence that applied under the Fair Sentencing Act. Section 401C, Mr. Goodwin attempts to take advantage of Section 401, which changed the penalty structure for 841 offenses. But Section 401C is explicit. It says that it applies to defendants whose offense occurred before passage of the statute if the defendant has not been sentenced as of the date of this act. And Mr. Goodwin was in fact sentenced as of the date of the First Step Act. I think it's important to read 401C in conjunction with 3582C1B, which governs sentence reductions of this kind. 3582C1B states that a district court, it is an exception to the rule of finality, and it states that a district court may reduce a sentence to the extent expressly provided for by statute. And not only does Section 404 not expressly provide for application of Section 401, but 401 itself expressly provides that it does not apply where a defendant has already been sentenced before the passage of the act. For these 3 different but related reasons, Mr. Goodwin is ineligible for a sentence reduction.
Further questions?
The court has no further questions. Thank you.
Thank you. Ms. Exton, you have a few minutes for rebuttal, if you like.
I'll rest on my briefs unless the court has any specific questions.
Thank both of you for your great arguments, and thank you for expediting the arguments today. I think the court has a clear impression of both positions here, and we particularly thank you, Ms. Exton, for being court appointed. It is a position that this court takes to appoint very competent lawyers. We oversee you quite a bit with the committee that I, in fact, chair the selection of it, and thank you for your service here today. And thank you on the part of the government too, Ms. Tesla. All right, we'll proceed to the next case very quickly. Case will be United and hear from the appellant's lawyer today in the case of United States versus Powers.
Thank you, Your Honor. Will Drake on behalf of Mr. Powers. First, I just want to note for the record that Judge Harris was my law school professor at Georgetown Law in the spring of 2007. And so I'm happy to be before her again and hope that my ability to answer questions has improved in those 15 years.
It continues to grade you, I see.
So, Your Honor, the fundamental disagreement here is whether this court should read its holding in Engel, which established that an indictment should be dismissed if the actus reus component of the crime is not alleged to have taken place in the venue in which charges are brought, along with its holding in Jefferson, which held that the actus reus component of wire fraud is the termination or origination of a wire into or out of the district in which charges are brought. We believe those cases go hand in glove and should be read together. The government disagrees.
Counsel, I actually do have a question about
Yes.
this. So I read Jefferson a little bit differently. I thought in Jefferson, we said that the conduct element is the act of causing a wire to be transmitted in furtherance of a fraud. If we assumed hypothetically that the language from Jefferson that I just quoted is the court identifying the conduct element, then would this indictment be sufficient in your view?
So I take your hypothetical. I believe my reading of Jefferson is that Congressman Jefferson was in Africa at the time that he caused the wire to be transmitted from Kenya to Kentucky. I believe it was Kenya to Kentucky. And so there, his actus reus of causing the wire was not within the Eastern District of Virginia, that the scheme to defraud, the devisal of the scheme to defraud took place in the Eastern District of Virginia, but that the actus reus component did not. I think that if the court holds that causing a wire to be transmitted into or out of the district would suffice, I think that the language in this indictment still may not achieve that, because as we note from the record, and I would like to at some point this court to a citation from the record, the U.S. Attorney's Office in this case was not aware of where these wires came in or out of the district, whether they terminated in or originated in the district, and they weren't able to allege that with sufficient particularity at the time of indictment. And so our position would be that even under that standard, I don't believe that this indictment language would be sufficient. And getting to that portion of the record, at the motion to dismiss hearing on the question of improper venue, which is located at Joint Appendix 274, the government stated, when we did the indictment in this case, we knew we had Bank of America, but we weren't sure where the processors were. We hadn't gotten clear information about where they were sent.
Counsel, why are we looking at this? I think your briefs told us we're supposed to look just at the indictment, right? This is like a motion to dismiss. We look at the indictment and see if what they alleged is true, would that be sufficient? And they've alleged that within EDVA, the defendant knowingly transmitted and caused to be transmitted interstate wires in furtherance of the scheme. So the wires could have passed through, started there, ended there.
I think that the reason that it's important to look at the government's thinking here is because the government was very clear that at the time of indictment, it didn't know that information. And so it chose to generally plead
So
that.
if you had filed a bill of particulars or something and they had responded, oh, we don't know, we can't fill in the blanks, like maybe that'd be a different question. But instead we're here on a motion to dismiss the indictment and we just look at the indictment.
That's true. But I think in terms of deciding whether this indictment is ambiguous and whether it is poorly drafted or whether it is the result of a conscious decision to avoid specific pleading, I think it is important to understand the government's motivation. So if we're looking at the words on the page of this indictment and try to determine.
Is that the standard, whether it's ambiguous, poorly pleaded, not particular enough, or is the standard whether it alleges the elements of the crime?
It is whether the words on the page within the four corners of the document allege the elements of the crime. And I think that it's helpful to the court to understand why our contention is that that is not the case. It could not have been the case because of the admission by the government before the court that they believed, based on the law of the Fourth Circuit at the time, that all one needed to put in an indictment is in the Eastern District of Virginia, divorced from a connection to any particular element within the crime itself, whether that be a mens rea component or an actus reus component.
But Judge Rushing mentioned bill of particulars. You did file a bill of particulars, but you only filed it relating to the material misrepresentations of the alleged fraud. Why didn't you include, at least in a bill of particular, as to venue in that?
So the discovery of the issue with venue came very late in the preparation for trial. The government had expressed a desire to handle venue by stipulation. There were many draft stipulations, and on the night before the decision to sign that stipulation, trial counsel discovered that a FBI 302 established that the witness who would be establishing venue could not confirm whether the wires in question passed through the Eastern District of Virginia or through Texas. Because of that, he stopped the stipulation proceeding, and when informed that a superseding indictment was going to be issued to fix a different error in the indictment, he requested that the government fix the pleading defect with regard to venue, and he was turned down. This was the result of significant back and forth between trial counsel and the government leading up to trial, several letters, several draft stipulations, request for the superseding indictment to fix the error, and ultimately a motion to dismiss the indictment for failure to properly plead venue. At that motion, the court heard from the government that he had done the research and realized that he did not need to allege, in his thinking, that the actus reus of the crime passed through the Eastern District of Virginia, and concluded by saying, if you allege the Eastern District of Virginia, just those words, you're fine. We disagree. We believe that the holding and angle requires that the government allege facts that, if proven true, would establish proper venue. But I heard a question. I apologize. If the court adopts the government's pleading standard here and no longer requires that an indictment allege venue with regard to the essential conduct element of the crime, that level of pleading will almost certainly become the norm. And that change in the pleading requirement will eliminate a defendant's ability to litigate an indictment's facial defect on venue pre-trial. And venue will only be litigated at trial based on evidence presented to the jury. And that would be a shift in the pleading requirement that will eliminate the very right that the Constitution enshrines to only be hauled into a courthouse for trial if that courthouse is where the criminal conduct occurred. Once the issue is before the jury, that right essentially has been eliminated because you've already been hauled into court. So, as an aside, we'll note that in U.S. v. Collins, this court held that if a defendant doesn't raise a facial defect with an indictment as regard to venue pre-trial, that issue is waived as to the indictment. A pleading standard that only requires in the Eastern District of Virginia will eliminate the ability to point out a defect. It's so broad that you cannot identify an objection to it. And so waiver will become 100%. Beyond waiver, we also like to note the enormous amount of court and jury time that will be wasted if we have cases going to trial without allegations of venue that can be litigated pre-trial. This will always be a jury issue in the Fourth Circuit if all we have to allege is in the Eastern District of Virginia, a crime occurred without alleging the particular elements. And I direct the court to the case of U.S. v. Bowen, in which the government alleged that a crime had taken place in the Eastern District of Virginia, the crime of harboring a fugitive. What had happened in the Eastern District of Virginia was that the arrest warrant had issued, but the harboring itself took place in South Carolina. Therefore, the court held there that because the essential conduct element of harboring did not take place in Eastern District of Virginia, there was no venue. If that had been litigated pre-indictment, where the indictment were required to allege whether the arrest warrant took place in Eastern District or the harboring took place in the Eastern District, there would have been no trial. And that waste of resources and that elimination of the right to be tried in the courthouse in which the conduct occurred would not have been eliminated. So while we read Jefferson and Engel in concert, and while we believe that when you're applying Engel, it makes sense to look at other cases that have established the essential conduct elements of a crime. The government disagrees and says that Jefferson is a sufficiency of the evidence case. We disagree. We believe that Jefferson essentially just identifies, for the purposes of venue, what is the actus reus component of sending or receiving a wire for wire fraud. And we believe that it's perfectly appropriate for this court to rely on cases that identify the essential conduct element, whether those cases be litigating whether venue was proven at trial or whether that venue was pleaded appropriately in an indictment. I'd like to move to sentencing, Your Honor, or I can hold that to my reply, depending on your preference. I see that I only have 3 minutes left. We just want to state that the law of the court here in the Fourth Circuit is that a judge needs to specifically address all non-frivolous arguments presented by a defendant for a below guideline sentence. There's nothing in the record that would establish that this judge did so at sentencing or in its memorandum opinion. We think the record on that speaks for itself.
I mean, your briefs, though, before the district court judge, I know you were disputing whether these guidelines were based on sufficient data, but the thrust of your argument is that the amount of loss is a poor proxy for the seriousness of the offense and the moral culpability of the defendant, right? And it seemed to me that the district court judge went to great pains to explain why each of these enhancements and the sentence as a whole actually was an accurate proxy in this case for moral culpability and the seriousness of the offense. The judge even recalculated the amount of loss and the number of victims because he thought that they were relevant. So, I take your point that he didn't parrot your brief, but he seemed to both in the hearing and in the written opinion address the thrust of your argument.
Respectfully, I would disagree. I think the only time that he specifically engaged with the argument, he indicated that he was unsure whether it was his place to accept an argument about the reasonableness of the fraud guidelines or whether that was an argument that should be made to the U.S. Sentencing Commission. And I think that question really muddied the waters about whether this judge was engaging with this argument, accepting it or rejecting it, and explaining his reasons why, as is required by the Fourth Circuit.
Do you think he didn't know the law?
I think this judge wasn't sure whether in this case, an argument on policy with regard to the sentencing guidelines, that they were unreasonable based on their deterrence factors, based on the seriousness of the offense, whether that was a policy argument should be made to the U.S. Sentencing Commission rather than an argument made at sentencing.
Well, but counsel, I feel like what's going on here, the judge is right, I think, that if you understand the argument being made as it is procedurally improper to impose this guideline, there's something wrong with the guideline, the backing is insufficient, it wasn't adopted properly. If that's the argument, it's not for the judge to consider. If, on the other hand, the argument is what I actually think it was, which is, no, I'm looking for a variance in this particular case. And one thing I want you to know is that the guidelines often overestimate the seriousness of the crime because of the focus on the amount of loss. Then isn't Judge Rushing right that if we formulate the argument that way, that is addressed when a district court sort of carefully explains why, in this case, this sentence does reflect the seriousness of the crime?
I think that might be true if the judge had specifically addressed that argument. But all that we have is pulling together implicit addressing of the argument based on the sentence provided and an attempt to engage with the enhancements themselves, rather than the idea that this enhancement in particular does not deter and will not deter others, which is one of the 3553A factors. And so I think that in this case, and I recognize that I'm out of time, but I wanted to finish your question. I think in this case, we can tell from the record that this specific argument was not engaged.
Thank you, Mr. Drake. We'll hear from you. Have some time left for rebuttal. We will now hear from Mr. Atkins.
Good morning, Your Honors. May it please the court. I was going to start with the venue issue, but I might just pick up on the sentencing challenge and then move to the venue issue. And I'd like to start with a point you made, Judge Rushing, which is that the district court clearly rejected the underlying premise of the defendant's policy challenge. Judge Rushing, as you correctly pointed out, the underlying thesis or the central thesis, the core of the defendant's challenge, his policy challenge, was that loss was a poor proxy for the seriousness of the offense and the defendant's culpability. That is exactly how he framed it. And the district court was unequivocal that loss did in fact, in this case, not as an academic or a policy matter or a theoretical matter, but in this case, loss did make the amount of loss did make the offense that much more serious and did weigh heavily against the defendant. I can provide the court with a few examples. There were 2 or 3 times during the sentencing where Judge Alston stated that he could not ignore the fact that there were 41 victims in this case and that the amount of loss is $23 million. He said that both at the sentencing and in his subsequent motion. He pointed out that whether the defendant realized it or not, his actions were grave because he didn't just defraud a few people out of a few dollars. And then in italics, Judge Alston wrote, he defrauded 41 people, at least 41 people out of $23 million. Judge Alston called the number of victims both staggering and significant, and so that equally astounding was the amount of money the defendant had defrauded, both collectively and individually. So the entire sum, and then on a victim-by-victim basis. And then he provided 3 examples of the most egregious cases: $4 million for Andrew Schwartzberg, $3 million for Jay Gupta, $3.5 million for Jason Donahue. The court again went back to the point that he couldn't ignore these facts, saying that it had not, could not, and would not ignore these facts. On the issue of sentencing disparities, the court went again to the issue of loss, rejecting the defendant's case comparators, holding, for example, that the defendant's reliance on the Almiral case was misplaced because the loss there was between $1 and $3 million. And here, of course, it was over $20 million. And the same point was made with regards to the defendant's reliance on the Stopchinsky case, where the district court said that loss there was about $200,000. And of course, here it's significantly more. The court stated that it was aware of the kind of sentences that were available, but thought that 151 months was appropriate, and again said that 151 months was appropriate to reflect the seriousness of the offense, provide just punishment, and promote respect for the law. And we cited this court's decision in Nance in our brief, and I think that's really on point. We know from Nance that when a district court rejects the central thesis of a defendant's argument, it doesn't have to then address every data point marshaled in support of that argument. And I think that really applies here. There's no question that the district court considered loss to bear extremely heavily on the defendant. And of course, that makes sense because the loss was massive. And as far as culpability, well, there was only one defendant in this case, so that's not really a very good argument. I'm happy to answer questions on sentencing, but I can also move to the venue challenge.
Move to venue.
On the venue issue, and again, Judge Rushing, I think you made this point earlier, there are really 2 or 3 sort of black letter law principles that I think have to guide this court's assessment of the venue challenge. The first, we cited this court's decision in Rendleman in our brief, and Judge Alston relied on it. Rendleman tells us that an indictment is sufficient if it alleges the essential elements of the offense, allow the defendant to know what he has to defend against, and to allow them to plead acquittal or conviction in the future. That's Rendleman. And then there's Rule 7. Rule 7 tells us that indictments have to be plain, concise, definite written statements of the essential facts of the offense. I don't think there's any question that this indictment satisfies Rendleman and the cases Rendleman relies on, or Rule 7. And I don't really take the defendant to be arguing otherwise. What the defendant is in fact saying is that there's a venue defect here. And I think the best way to understand that argument is to go back to the very beginning. That argument was premised on the defendant's review of pretrial discovery and evidence. The defendant made that point in his motion, to which he actually attached pretrial discovery, 302s, emails between government counsel, as well as a hearing on the motion. And the defendant, I think the argument is best highlighted by something the defendant said in his reply below, and this is at JA 93. But the defendant says that there's a serious question whether the government will be able to prove venue in this case. And Your Honors, that argument should sound very familiar to this court because it's exactly the same argument the defendant in Engel made. The defendant in Engel moved pretrial under Rule 12 and stated that there appears to be no evidence of conduct in the Eastern District of Virginia. And this court, despite the way the parties had framed things, held that actually the question is much more limited because we're dealing with a challenge to an indictment in the Rule 12 context. And under Rule 12, challenges like this need to be decided on the face of the indictment and without recourse to material beyond the indictment. That's number one.
Why didn't you add more details to the superseding indictment? It seems to be that might have been a time you had some indication of this defendant's concerns.
Sure. So my best answer is what the AUSA's answer was below. So initially, the AUSA explained that they didn't charge venue because at the time they were charging, so this is at the time of the first indictment, they knew they were dealing with Bank of America, but they hadn't ironed out all the specifics. And so given this court's precedent, presumably Engel, they kept things more general. the AUSA's reason for not charging, to keeping things more, to charging things in a more specific way at the superseding indictment, because surely everything had been ironed out by then, was that at that time, and this is the first page, I believe, of the government's response in opposition below, which is that at that time, trial was about a week away, and the defendant's opportunity to file motions had already passed, and the defendant had already had a motion to file additional motions denied by the district court. So the AUSA explained that he didn't charge it in a more specific way because he didn't want there to be an 11th hour challenge to the indictment, which of course is exactly what happened. The defendant's motion was actually untimely, although Judge Alston didn't address that. But that is in fact the reason that the AUSA explained. But more fundamentally, just going back to where I began, I don't think the law demands it. And I don't think Rendleman, Rule 7, or this court's decision in Engel demand the government to go wire by wire in its indictment. Happy to answer any of the court's questions. I'm also happy to sit down.
Judges, thank you very much.
Thank you.
Mr. Drake, you have a few minutes of rebuttal.
One last short point on this issue of the motivation for not changing the indictment. I think the government was clear at the motion to dismiss hearing that it believed that the precedent in US v. Meta allowed it to vary from the indictment with regard to the details of a wire. In that case, the wire went from Michigan to Maryland, where the trial was, rather than, I believe it was Missouri to Maryland, where it was indicted. And Meta said, well, you can vary because in either instance, Maryland provided the venue. The assistant U.S. attorney in this case said that based on that, he believed if you can vary from the indictment to what's proved at trial, then you need not plead it at all. And that is very clearly the decision that was made here, to not plead specifically venue because venue had not yet been determined. That's the motivation. And I take Judge Rushing's point that we look at the document on its face. But here, where we're trying to interpret the meaning of the words, I think that it is appropriate to look at what the U.S. Attorney's Office is telling us about why it chose those specific words. I yield the balance of my time and happy to answer any questions or sit down.
I want to thank both counsel for adhering to the court's concern with the COVID here, recognizing the expedited arguments, but nonetheless, we have a full explanation of your arguments here. Both of you presented your cases very well, both here in your briefs, so thank you very much. I should also point out, normally we come down, Fourth Circuit takes pride in the fact we come down and shake your hand. We're not going to do that in the midst of a COVID situation, but we hope the day will come when we will return back to that practice. Thank you both all for your arguments. We'll proceed to the third case here.
and wire fraud cases are much, much more serious than the tax. Tax cases, the maximum punishment is 3 years. Bank and wire fraud, it can be up to 20 or 30 years. So there's certainly more serious in that regard. In terms of the prejudice, it kind of segues into the fact that what you had was that they had alleged that for 4 years between 14 and 18, she had filed or facilitated filing false tax returns. And then all of a sudden, they allege that a year and a half later, she starts into a completely separate scheme that's really not related to the preparation of taxes or related to deductions or income. And that segues into my sort of overarching argument that when you take that in connection with the court allowing in the prior convictions, I didn't try this case, but I read the record carefully and talked to the attorney that did try it. And I know Mr. Sheehan, I know the lawyers that tried this case, but if you read this record, Judge Dumar let those convictions in. And then the case, from my reading of it, all it was ever about was those convictions, every opening statement, witnesses, every time there was a talk.
Can you just clarify me, as I understand it, you are not arguing in your brief that the district court order allowing the evidence in, the convictions in for these limited 404B purposes, you're not arguing that that was incorrect. You're arguing that, what I think you're about to say, that whether or not that was correct, they ended up using the convictions beyond the scope of that order.
I think the way I would say that, Your Honor, I think my stronger argument is that I did make sort of the allegation
I don't see the other argument at all in your brief.
But certainly my main focus is it exceeded the scope of what it was allowed for in the way that it was used. One of the things
I don't want to take up a lot of your time, but I really want to make sure you have a chance to explain this to me, because I'm struggling to sort of get my hands around this. The district court allows the evidence for the convictions for these limited 404B purposes. And your argument is that the government went outside the scope of that use and used them to impeach, to sort of call into question the trustworthiness of the defendant and her character witnesses. But you're allowed to use convictions for that purpose. That's not a 404B. That has nothing to do with the admission of the evidence under 404B for the limited purposes. That comes in under 404A and then those other rules about using convictions you're allowed to use it as character evidence going to trustworthiness. And so I'm not understanding how these two arguments sort of fit together. Is my question clear?
I think it is, Your Honor.
Okay.
And again, I think the way that I just think the way that the government used it, and I tried to cite all of the different, I think I got them all every time they mentioned it in the brief. It tainted the trial from the standpoint of, Judge Dumar allowed it in, gave a limiting instruction, but he certainly didn't give a limiting instruction every time it was used or argued. And I realize perhaps he's not required to, but this court is certainly aware that prior convictions are some of the most damaging evidence that any defendant can face, particularly in the government's case in chief. And one of the things the government kind of dinged the trial lawyer for, if that's the right word, was that the trial lawyer that defended Ms. Tall himself mentioned the convictions and brought them up a few times. Well, once you know they're coming in as a trial tactic, as a trial lawyer, obviously you want to confront it and not leave it for the government to bring it up all the time. But my overarching argument, Your Honor, is the combination of the way that was used and the fact that Judge Dumar allowed the government to put on evidence of separate crimes that happened a year and a half, much more serious crimes that happened a year and a half after the tax case. My reading of the trial record and what I would say to the court is the sum of that, whatever the intention was, is that Ms. Toll is a bad person and she's being put on trial for what she is, not for what she did. And that's sort of not where we're supposed to go. So I hope that answers your Honor's question. And unless anyone else has any other questions, I think those are the points that I would like to make.
Thank you. You have some time in reserve for rebuttal too.
Yes, sir.
We'll hear from Mr. Sheen for the government.
Good morning. May it please the court. My name is Daniel Sheen and I represent the United States in this appeal. Given the court's comments about the COVID situation, I'll try and keep my comments brief. With respect to the sufficiency of the evidence, I would just refer the court to our statement of the case in our brief at pages 15 through 30, which clearly set forth the overwhelming amount of evidence that was used to convict Ms. Toll with both respect to the 33 counts of aiding and assisting in the preparation of false tax returns and the 5 counts of wire fraud. I'd like to spend the bulk of my time addressing the main points raised by the appellant this morning, and I'll start first with the use of the prior convictions. Judge Harris, you raised a very valid point that we made in our brief that once Ms. Toll testified and once her character witnesses took the stand and testified about her reputation for truthfulness and honesty, that was impeachment evidence that came in during Ms. Toll's presentation of the case. And just to give the court kind of a visual, during the government's case in chief, we had 20 witnesses. There was only one witness who testified about Ms. Toll's criminal history in our case in chief, and that was the special agent who was involved in the investigation. Her testimony took up about 4 pages in total out of the thousands of pages of the record that's before the court here in the government's case in chief. And it was limited to simply just introducing into evidence those convictions and reading into the record a stipulation that had been entered into by Ms. Toll. Contrast that with the use of the prior convictions in Ms. Toll's case in her defense. She had 7 witnesses total testify, including herself. And by my count, 5 out of those 7 witnesses testified about her criminal history because her attorney asked them about her reputation for honesty and truthfulness in the community. And then also proactively on direct examination brought up her criminal history. And he did that with Ms. Toll as well. So to the extent the appellant complains that it came up too much during the trial, the majority of it came up through the presentation of Ms. Toll and her witnesses in her own defense. And that was properly within the scope of cross-examination, given the nature of the testimony on direct examination. I would also add, and we made this point in our brief, that when Ms. Toll gave testimony on direct examination about her criminal history, it was misleading at best. And I would also contend that it was just wrong and not truthful. She made misleading statements that I think mischaracterized the nature of those prior convictions. And that was part of the reason that it became a bit of a sideshow during her presentation of her case. I would point the court to this court's decision in the Johnson case, which deals with 404B, and it says, where a defendant by her own testimony and the testimony of her other witnesses attempts to depict herself as someone whose character and conduct is at odds with the possession of the state of mind that's required for a guilty verdict, she can be considered to have forfeited the protection of 404 with respect to character evidence. So that's exactly what happened in this case. We've also argued in our brief that the government did not go outside the scope of the district court's 404B order in referring to Ms. Toll's criminal history. The district court issued a thorough opinion, which is on the district court docket at number 92, which explains, he did not believe, after having the benefit of observing the 7-day trial, that he did not believe that we went outside the scope of the order that he issued pertaining to her criminal history, and the way in which we brought up her criminal history was proper in order to impeach her and her witnesses who testified on her behalf. To the extent the appellant raises the issue of 404B as to whether the district court was correct in the first place in allowing that evidence, we contend that the district court got that issue correct for the reasons stated in its order. I would also like to orient to the court, to the record, to explain one of the primary reasons why the criminal history was brought in the first place. We explained at trial, as part of the process of applying to be a tax preparer with the IRS, an individual has to submit an application to the IRS and provide information about her background so they can screen and make sure that someone has the proper qualifications to prepare taxes on behalf of the public. And as part of that application process, an individual has to state whether or not they've had any prior felony convictions. The evidence that we presented at trial was that when Ms. Toll applied for her tax preparer identification number, she did not disclose to the IRS that she had those prior criminal convictions for embezzlement and forgery. And had she done so, she never would have received a preparer tax identification number in the first place. So we contend that that showed her intent and her willful state of mind in connection with the operation of the business by the fact that when she went to apply for this in 2010 and 2011, she failed to disclose the IRS the truth about her criminal history and background. On the issue of joinder, the district court correctly concluded that the wire fraud offenses were properly joined with the tax-related offenses under Rule 8A because they were of the same or similar character. The district court reasoned that all of the offenses involved Ms. Toll's false and fraudulent actions taken on behalf of her tax preparation business, Phoenix Financial Tax Service, in order to deceive particular victims. In the case of the wire fraud, the victim was a lending institution called Fora Financial. In the case of the tax-related counts, the victim, of course, was the IRS. The evidence presented at trial and outlined in the indictment showed that all of the actions that she was taking that were criminal in nature were on behalf of her business and were done with the motive and intent to preserve and promote her business in order to make more money for her business and for herself. The loan applications were submitted in the name of Phoenix Financial Tax Service. The tax returns, of course, had the name of Phoenix Financial Tax Service on them and were submitted to the IRS using specific employer identification numbers and e-filing numbers connected to Phoenix Financial Tax Service. And bank accounts, of course, that stood to benefit from receiving these funds were in the name of Phoenix Financial Tax Service. They were business bank accounts in connection with the wire fraud counts. Another connection between the two charges that is mentioned in the indictment is the fact that Ms. Toll used false and fraudulent tax returns in connection with both sets of crimes. So with the tax-related counts, of course, it was the false and fraudulent tax returns that had materially false items on them that were submitted to the IRS. With the wire fraud counts, she had to prove her proof of ownership of the company. So she submitted a false and fraudulent corporate tax return for the tax year 2018, which was never actually submitted to the IRS. But she submitted that to Fora Financial in order to convince them to lend money to her that they otherwise would not have done. So that's another connection between the two schemes that was sufficient for purposes of joinder under Rule 8A. We think the joinder was very strongly supported by two out-of-circuit cases that we've cited in our brief, the Alexander case from the 7th Circuit and the Levine case from the 10th Circuit, both of which have upheld joinder in very similar circumstances where different fraud-related charges were joined together and centered around the operation of a business, and the crimes of the defendant were intended to promote or preserve the business. And that is, we contend, exactly the case that was presented here. And we would urge the court to follow similar reasoning to the Alexander and the Levine cases because they're in keeping with this court's general precedent in regards to joinder. This court has specifically said that the same or similar character requirement under Rule 8A is not onerous for the government to meet. This court permits very broad joinder because of the efficiency of trying a defendant on related counts in one case and because of the concerns of having to impanel additional jurors, wasting limited judicial resources, and duplicating witness testimony, all of which were concerns in this case. The district court also did not abuse its discretion in denying severance under Rule 14A, primarily because Ms. Toll just did not make the strong showing of prejudice necessary to warrant that prior to trial. This court has said that convincing a district court of severance is a daunting task, and speculative allegations of prejudice do not suffice to warrant severance of charges. And that's exactly what Ms. Toll presented at the district court level. It was a speculative argument and allegation that trying her on both sets of counts would prejudice her case in general, but there wasn't any specific showing or proffer that she intended to testify as to one set of counts, but refrain from testifying on the other set of counts. And even if the court concludes that there was any error associated with the court's analysis on Rule 8 or Rule 14, that error was harmless for several reasons. The first would be the overwhelming amount and nature of evidence that established Ms. Toll's guilt on both sets of charges. And as I said earlier, that's outlined very clearly in our brief at pages 15 through 30. Second, if there was any error, it was harmless because of the limiting instruction that the court gave with respect to the consideration of separate charges. The district court clearly instructed the jury that it was to consider all of the counts separately, and a guilty finding on one count should not control the jury's verdict as to another count. And the third and final reason that any error was harmless in this case is because the evidence was distinct and easily segregated as between the tax-related counts and the wire fraud counts. So there was no risk that there was going to be an improper spillover effect and the jury might be inclined to find Ms. Toll guilty on one set of counts just because of the evidence on another set of counts. The evidence was very distinct, both in terms of the documents the government presented and the witnesses that the government presented as to wire fraud and the tax-related counts. Just with respect to the issue of timing, we don't dispute that there was a gap of about 18 months between the date of the filing of the last fraudulent tax return and the submission of the fraudulent loan applications to Fora Financial. But the cases we've cited, specifically, I believe the Alexander case, shows that joinder is still permitted when the offenses are of a like class, even if they are not temporally related. So we would contend, based on just the similarities between the offenses, the involvement of the business and the operation of both sets of schemes, that 18 months difference is not enough to find that there was any error in joining the two offenses in this case. I do have 8 minutes left. I don't have any more to argue, but if Your Honor has any questions, I'd be happy to address them. Thank you.
Thank you, Mr. Sheehan. Mr. Wood, you have.
Yes, Your Honor, just a couple of brief points. I won't reply what I said. First of all, with the United States analysis of the joinder, I don't think that it's a proper legal standard to apply to say who benefits from the offense. In the case that Judge Harris mentioned, I think anytime somebody commits offenses, they feel like they're going to benefit from them in some way, be it possessing a firearm after being a felon or committing a carjacking. So I don't think that the analysis that the government's position that her business benefited from both offenses is the right legal analysis. I realize that joinder, as Mr. Sheen pointed out, is onerous and it's a heavy burden for us, but it doesn't mean that it's an impossible burden. And particularly in a case like this, which there is a big gap in time and the second set of offenses are much more serious than the first set. With regard to harmless error, been coming up here a long time, banging my head against harmless error. The government always says that we put on more evidence than we needed and it didn't really matter because even if it hadn't been in there, that we would have still had plenty of evidence to convict somebody. I've kind of always analogize that to somebody who's being treated for a serious illness, gets shot and killed, and you kind of say, well, it didn't really do anything because they were going to die from the illness anyway. I think that that's at best a lot of times a speculative exercise, and I would submit to you that in a case like this where you have the government calling one of their first witnesses to tell the jury this person's been convicted of 3 other crimes and we're trying 2 sets of cases that are completely unrelated, both factually and temporally together. I get back to where I started. I think the combination of that tainted this case and that Ms. Toll, the case should be remanded and Ms. Toll should be given a chance to have 2 trials that focus on 2 separate and temporally unrelated sets of facts. Thank you.
All right. I want to thank both of you for your consideration and ideals of representing your clients zealously within the bounds of the law. As we proceed forward, I do want to also thank Mr. Woodard for your court representation here today. Without the services of those who a court appointed, it would be very difficult to provide the kind of quality representation you exemplified today. And I also thank the government's counsel for your very good argument too. So with that, normally we'd come down and shake your hands. Both of you know that well. We're not going to do that during the COVID times, but we're about to conclude court for this session and move to September when we come back. We hope that the situation of health and concerns will be abated to the point that we can do that. In the meantime, we wish you all well.
Thank you, Your Honor. Thank you.
Instructions I've given to the other three cases we've had, you know by now perhaps that we have identified a COVID situation this morning here, unfortunately. So we'll ask that you keep your mask on during your arguments. I also will say this panel was very concerned about this matter, and we came very close to deciding this matter on the briefs, but we decided that we would proceed with the arguments and ask that you do so expeditiously. Try not to get too much into matters that are in the brief that are clearly before us, particularly the facts of the matters. We've read those very carefully. So go directly to the issues and proceed in a manner as best you can to make sure you fully present your case to us. And we appreciate that. With that, we'll hear from the appellant this morning.
Thank you very much, Your Honors. Steve Van Stemport for the appellant, Keith Nelson. And I'd like to reserve 7 minutes, I think, for rebuttal, if that's okay. Hopefully I'll do this expeditiously and we won't need the whole time. The issue in this case is whether it's plain error for the district court to believe that a mandatory minimum applied, even though there was no mandatory minimum that did apply. And I think you can look to the plain language of the statute. I think even the government agrees that the district court could have imposed a term of supervised release that was 0 months, right? So everybody agrees that the district court had the discretion to impose 0 months. And yet if you look at the transcript, it's very clear that the district court believed that it couldn't go down any lower than 5 years. And the probation officer's report and violation report and calculation worksheet is consistent with that. So what we have is a situation where the district court thought it didn't have discretion to go below 5 years, and that's why the 5 years was imposed. Now, if you look at the, and of course, our argument is that this is procedurally unreasonable. That's why the 28J letter submitted by the government doesn't move the ball. That's the Brunner case from the Second Circuit. The argument there was that the 5 year sentence of supervised release was substantively unreasonable. That's not our argument. Our argument is the procedural unreasonable. If you look at the terms of the statute, it's very clear. 3583 subsection H says the court may impose a supervised release on revocation. And the only way that the court's discretion is bounded is on the maximum, right? The imposition of the supervised release can't exceed the calculation under the subtraction rule, which we've discussed and which this court has also discussed in the Thompson case. And then with the guidelines, the same language applies. It's unambiguous. And it applies again that the court may impose, doesn't have to impose any term of supervised release, but it may. And again, the only limitation is that it can't exceed the maximum under the calculation of the subtraction rule. As this court in United States v. Forrester, which we've cited in our brief, that's an unpublished case, but the court did recognize that, yeah, in this context where you're where it's a revocation and you're imposing supervised release upon revocation. The only thing that applies is USSG, the guidelines 7B 1.3 G2, and there's no minimum. So the question, of course, is whether this error is, I really don't think there's a question that there's an error. The question is whether it's plain. And I think the rule is, Olano says, look, if it's obvious that there's an error, it's plain. This case, in the Trejo Ruiz case, also explained that, look, if the explicit text of the statute resolves the issue, then the error is plain. And that makes sense because you don't necessarily need a court to reiterate what the statute already unambiguously says.
Counsel, haven't 3 other circuits concluded that this error is plain? That an error of applying a statutory mandatory minimum that applies to an original sentence, it doesn't apply to a revocation sentence. It's error, it's plain, and that it does affect substantial rights. I think the 7th, the 5th, and the 3rd Circuit have all decided that in the context of drug sentencing in 841B1. I say that in support of you.
Yes.
You would have us agree with them, would you not?
I would love to agree with you. I don't know the cases, right? I mean, I'm not sure about those cases. They weren't in the briefs.
You don't have to take my word for it.
But if I will take your word for it, and I would love to take your word for it. But I think that's clear, right? I mean, it makes perfect sense. If the statute says something and the statute just isn't followed, it's a plain error.
Can I ask you a question about remedy? Just if we assume hypothetically that there was a plain error here that affects substantial rights, you're asking us to vacate the entire sentence, including the term of imprisonment. And I do understand that we would usually do this under the sentence package doctrine, but I just want to make sure I understand what's going on. Your client has already been sentenced to the maximum statutory term of imprisonment. Is that right?
Yeah.
Because I think normally our intuition maybe would be like, look, the district court might want to lower the supervised release term now because it turns out that there is no mandatory 5-year minimum. And as a result, might go up a little on the term of imprisonment. But given that this term of imprisonment isn't going up, is it necessary to vacate the term of imprisonment? I guess that's my only question.
It's
probably doesn't much matter.
Our position is, look, this is a package deal, right? And again, given the implications potentially here, I think it's worthwhile to send it back to the district court for plenary resentencing, just so that the district court can understand exactly the parameters of its discretion. And again, I think that would include the active time. But yes, you're right. He is already serving his active time, right?
Okay.
Yes. I'm going to leave it at that unless there are further questions.
All right, thank you very much. We'll give some time for rebuttal.
Thank you.
And we will hear from Mr. Isabel. Did I pronounce that right?
Yes, Your Honor, you did. Isabel.
Thank you.
Thank you. Good morning, and may it please the court. Andy Isabel on behalf of the United States of America. The district court in this case did not plainly err in calculating Mr. Nelson's available statutory and guideline terms of supervised release for 2 reasons. The statute in question, 3583H, does not plainly establish a guideline range of 0 for a subsequent term of supervised release.
Can I ask you a question about this? As Judge Rushing said, there are 3 circuits that have already concluded sort of to the opposite, that on plain error review, it is a plain error to read that term as imposing any kind of a minimum. And not only that, but the government conceded, the United States conceded in 2 of those cases, both that was the correct reading of the statute and that it was sufficiently plain, that it survived plain error review. And I guess my fully understanding that you are not in charge of, the United States government's litigation positions, but it is confusing for us when the government takes one position in other circuits and then comes into ours and takes a different position. And I don't even know if there's a question there or maybe just a suggestion that somebody at a high level take a look at this and see if they can get the government's position straight on this.
That suggestion is well taken, Your Honor. I appreciate that. And Your Honor, I think that to answer what may not have been formed as a question, but I believe the point that you're getting at is that, in fact, I believe the answer to that resolves the fact that no plain error happened here because the district court had very little to no guidance from the 4th Circuit regarding this issue. It flatly has just not been answered in a plain, clear way. And given the analysis of plain error that the defendant himself and both parties agree is taken into account here, there was no guidance affirming that for the district court to follow. And given that is the other point that I was about to make, is that the law of this court nor the Supreme Court has been plainly settled pertaining to this issue. And this court found held in the Treo Ruiz decision that the appellant cited, that if there is no plain ruling, then it cannot be plain error.
Well, but counsel, if the text of the statute is plain, and I should be clear that in those other circuits where the government conceded plain error, there was no precedent in those circuits on this question either. And there's unlikely to be precedent when you end up in this weird position, right? Where if the statute is so plain, it is unlikely that the question will have even made its way to the appellate court, because who's going to get it wrong? And so in those circuits, there was no circuit precedent, but it was just the terms of the statute were considered sufficiently plain or sufficiently obvious that the error was plain. I mean, if the terms of the statute are crystal clear, is it really your position that an error, you still have to wait for case law explaining what the obvious terms of the statute mean before an error can be plain?
No, Your Honor, that is not our position. Our position would be that the statute is not sufficiently as plain as the court may suggest. The statute certainly does give the district court discretion to impose a new term of supervised release after revocation and imprisonment. But discretion, the United States position is that discretion does not equal 0 months. And the statute, while not specifically, does implicitly refer to 3583K, which is indeed the statute that says a term of supervised relief for a defendant such as Mr. Nelson is 5 years to life. So given that 3583H does implicitly refer to the statute that sets the mandatory minimum for a SORNA violation, the United States position is that it is not sufficiently clear for a district court to look at that and say, oh, the range must be, the bottom end of that must be 0 because I have discretion not to put the defendant on paper. And hopefully that addresses your question sufficiently. And again, secondly, the law of this in this circuit has not been settled, as I believe we have noted and said several times here. And lastly, even if there was error and it was plain, it's not clear from the record here that the district court outcome would have been any different. In the judicial appendix, the district court in reaching its decision cites the defendant's long, complicated, and atrocious criminal history. That's on page 77 and 78. And during his discourse with the defendant, the district court said that this was the statutorily available sentence that he was calculating. So for those reasons, the United States position is that the district court did not commit plain error here. If I hear no further questions, the United States would gladly submit at this time.
Thank you very much.
Thank you.
Mr. Van Stempert, you have some rebuttal time if you want to exercise.
Thank you, Your Honor. I'm not going to take much time. I think we've already had this conversation about that there is plain error. As far as whether the outcome would be different or not, I mean, again, the cases are very clear that if the framework is wrong, if the parameters are wrong, then you got to send it back to the district court so that you can make the decision within the proper frameworks. And lastly, well, I mean, in terms of whether this court has settled this particular issue, I do think the language of the statute is so clear that you're in this position where there isn't going to be precedent because it's an obvious error that most courts aren't getting wrong. And of course, this isn't anything like a qualified immunity analysis, right? We're not looking for clearly established law. We're looking for plain error. And you can do that under the statute itself. So unless there are further questions, I'll leave it at that.
Counsel, I just want to again commend the two of you along with all of the counsel this morning. This panel is very appreciative for your extraordinary consideration of the particular health concerns that we have here in light of the COVID situation that exists here. We certainly wish health upon everyone here, and that in particular as we move toward Mother's Day this weekend, we all have mothers, some not, but those who do, mothers and grandmothers, may be a little elderly, and we don't want to take anything to them. Certainly, I don't want you to take it from this court. But thank you very much for your fine arguments. Mr. Van Stempert, I recognize that you are court appointed, and we could not do this work without court appointed lawyers to represent the clients in the manner that you've done in such an exemplary manner this morning. and likewise with the Government's Council. I thank you for your fine argument this morning. So, you know, the routine here, normally this court takes great pride in coming out and shaking your hand and exemplifying great collegiality, not only with each other as judges, but with the lawyers who come before us and the respect that we have for you. We will not do that today because of the COVID protocol, but we'll be back in September, and we certainly hope that the situation will be abated to the point that we once again can reinstitute that policy. So with that, unless there's something further from panel of members, I'll ask the Madam Clerk to adjourn court.
This honorable court stands adjourned, signed by God of the United States and this honorable.